I guess one of them amended, but the other one. Yeah. So.
Wow, but that's a
Well, I know the other one's 93, but I don't know what this would be.
it's only firearms.
It
It's 21st
All right, counsel, your client's here. If you could come up to the podium, please. This is docket 25-5593 FH, 25-5596 FH, 25-5332 FH, 25-4783 FH. People of the state of Michigan versus Tyrone Devontae Howell. Counsel, your appearance for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people in all files.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Howell, who is standing to my right on all 4 files as well. Thank you.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. You may put your hand down. Sir, have you taken any medication yesterday or today?
I took my daily medication.
All right, and does it interfere with your ability to understand me or your attorney?
No, Your Honor.
Is there medication you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
All right, and today I understand is a final criminal pretrial conference. I did have a conference with counsel in regard to what the plea offer was, which we can make a record of today. And I understand that's going to then be set for a plea because you are agreeing to take it. On behalf of the people, is that correct? And what is the offer?
That is correct, Your Honor. The offer covers all 4 of the defendant's files. The offer is for the defendant to plead guilty in file 25-5593 FH to count 3, assault by strangulation, and count 4, domestic violence, 3rd offense notice. And then pleading guilty in file 25-5332 FH to count 2, felonious assault. There is a sentencing agreement that was going to expire today if the defendant did not want to take it, to a fixed minimum of 36 months and for it to be concurrent across both of those cases because they are discretionary consecutive. The people agreed to dismiss the remaining charges, to dismiss file 25-5596 FH and file 25-4783 FH, and not pursue witness interference charges in the first 3 files for contacts that were discovered by my office that were made prior to today's date, April 8th, 2026. And just for the record, the estimated guideline range for these charges without that sentencing agreement is 38 to 76 months.
3876 without the plea deal. What is it with the plea deal estimated?
No, that's with the plea deal.
Oh,
Without the plea deal, they vary from case to case.
Okay.
The biggest one being 58 to 114, but with the amount of discretionary consecutives, it could be anywhere between 62 or 329 months.
All right, thank you. And counsel, you've discussed all of that with your client?
I have, Your Honor, and just for the record, I wanted to also, but we agreed on the, depart the, an agreement to the 36-month fix, with the idea that in hopefulness of being able to maybe go forward with the, some type of other boot camp if the court so consents to, which the court has indicated it would likely do, is my understanding from our conversation. And I have relayed that to Mr. Howell, but a lot of that would all, again, depend on his behavior between now and sentencing as well.
And once he goes to prison,
Yes.
it would be, I don't run the prison, so even if I consent, if he's not behaving, they may say no.
Yes.
Or delay it, so.
And I have relayed those factors to him as well, and he is in agreement. And this plea agreement, as I understand it, and I believe as the prosecutor and the court understand it, should at least legally make him eligible for the programming.
And what was stated is full, fair, accurate, and complete.
It is, Your Honor.
In fact, 36 months, although it's a bit of a downward departure, was done and specifically designed for the eligibility of SAI boot camp in his favor.
Yes.
Sir, is all of that accurate and complete?
Yes, Your Honor.
All right, and so, given that it's your intention to plead, and we're gonna set this out a couple of weeks, is that correct?
1 week.
1 week,
Next
Okay.
Wednesday at 9:30.
yes,
Wednesday at 9:30, so that would be April
15th.
15th. All right, then the remaining, well, let me just ask you this, sir. So you're gonna plead next Wednesday, you got a week.
Yes, Your Honor.
If you decide not to take, this is the final offer. This has been going back and forth, and these cases are getting old. So if you decide on Wednesday to decline the offer, we're gonna set this for trial, because this is a final pretrial conference. Do you understand that?
Yes, Your Honor.
All right. And did anyone force, threaten, or coerce you to enter into this agreement?
No, ma'am.
All right, very good. So we'll talk more about that on Wednesday.
Okay.
At this point, we have the issue because of the multiple letter writing, et cetera, violation of the no contact order, the issue of contempt. We have some people who's like to be heard.
Yes. This defendant has been continuously violating no contact orders. I went back in the files. It started when he was first released on the 2022 cases. We got a PA 53 violation report in 2023. It is continued through to 2026. This court told him on the record, you're gonna set him 93 days. And then he refused to come over last time. As I put on the record, pretty clear to the people, it was an attempt to try and avoid that from happening. I'm asking the court to sentence him to 93 days, as he said it was going to. I am going to ask the court that it be a single 93-day sentence, because the court could sentence him for 93 days in each of the 3 files with the no contact orders. But I'm asking it to sentence him to the 93 days, consecutive to what happens in the underlying file.
Response?
Thank you, Your Honor. Understanding that any sentence on a contempt of court finding would automatically be consecutive. I have explained that to Mr. Howell. He understands that any sentence on that conviction, because he did admit it to the court when he was here in January, would result in that. I believe that he is remorseful for the just not listening. And he has had to suffer as a result, not being able to have communication with family. Apparently he's had 2 deaths in his family, and he's not been able to communicate with them or to have any contact with family other than to find out that there were passings, and to be able to provide comfort as well as receive comfort from them. I believe that has made a pretty big impact on him. His behavior, I think, has improved. He has been getting medical care while in the jail for mental health conditions. And as my understanding, he has been complying with CATS. He's been programming over there at the jail. I would note that his, like as I indicated, his behavior, his attitude, I believe, have become much better. And I would ask the court, I understand the prosecutor's request. I'd ask the court to consider a lesser term for him, considering the fact that we are going to be looking into him, at least for a little bit, once he is sentenced, going into MDOC. And I would like to be able to get him started on that as soon as possible, if the court is willing, so that he can benefit from the more rigorous programming, not rigorous, the more varied programming that they have in Michigan Department of Corrections. So I'd ask the court to consider a lesser term than 93 days with that understanding. I'd also ask the court, Mr. Howell has asked me to convey that he understands that he has profoundly violated this court's order, as well as the district courts, and the loss of his family members and not being able to communicate regularly with family regarding that, because he has lost all of his privileges, period. And he now knows that the prosecutor's watching any conversation. Would respectfully ask that potentially the court grant him back some communication with family, so that he can at least be provided some support by family members with regard to the loss of members at this time. Thank you.
Sir, what would you like me to know?
Nothing really, besides I just been going through it with left for my cousin and my grandmother.
Sorry for your loss.
Thank you.
Sir, if your behavior continues on the path, when you go to prison, they're gonna keep you long after the 36 months. They don't have to release you. Even if I say it's fixed, they're gonna look at your behavior.
Yes, ma'am.
So you gotta straighten up.
Yes, Your Honor.
Nothing good comes from violating court orders or the law. End up in that jumpsuit away from your family and loved ones. Did you have something else?
The only thing I'm gonna say is that at no point in the letters that he was sending to the victim from other inmate accounts trying to disguise names did he ask about this. He was only ever focused on making sure this case got dismissed.
All right. Sir, in regard to the contempt, you get 93 days on all the files, but I'm going to run all the files together. So they'll be concurrent, however, it'll be consecutive to whatever sentence I give you on the other file. And is he getting credit on any of these? Because didn't we have the hearing on this? He should get some credit on this.
He would get credit towards 93 days when this started. If I remember correctly, that was at I think it was at the motion hearing for bond is when this all kicked off. So that's December 17th, 2025 is what I have.
Yes.
So he would be getting, effectively, he has served his time on the contempt, but the 93 days will effectively be taken out of any jail credit he gets on the underlying file. So it would be full 93 days credit.
Credit for 93 days. And then we'll figure out how that's all calculated.
And the,
What file is this on?
I'm giving him all three files. We'll have 93 days of credit for 93.
It's every file but 25
That's right.
4783.
because that's the control.
That's the
substance.
drug case.
25 what?
Dash 4783 FH.
Okay,
That's
sorry.
the drug case. There's no contact order there.
Yeah,
Yes.
so it'd be
93, 490.
It'd be on 5596, 5332, and
5593.
5593, yeah. Not on 478. Okay, great. Sir, I need you to behave. I will allow you to contact with your immediate family. If it is inappropriate, there'll be more contempt, and you will negate the offer.
Yes, Your Honor. Thank you.
Do you understand, sir?
Yes, Your Honor. I
It
do.
better be appropriate. I better not hear anything negative.
Yes, Your Honor.
Do you have any questions about what that means?
No, you got my word.
Yeah, Your Honor.
Okay, anything else we need to address?
I would just like to, Mr. Howell, we spoke downstairs, correct?
Yes, ma'am.
We spoke downstairs twice, correct?
Yes, ma'am.
And when I said I would make this motion regarding your contact with family, I indicated to you that it was just absolutely imperative that you follow it to the letter. Is that correct?
Yes, ma'am.
Because if you don't, this guy here is gonna be watching you.
Yes, ma'am.
And then all of this is off the table.
Okay.
All right, thank you.
Yeah, you'll just make his day if you violate, so you don't wanna do that, do you?
No, ma'am.
Make yourself happy, not the prosecutor.
Thank you, Your Honor.
Now,
Nuts and bolts on the credit. He got credit from 12/17/2025 through March 20th, 2026.
March 7th, you said?
March 20th, 2026.
What was the first date? Was that?
12/17/25 to March 20th, 26. That's the 93-day credit.
Perfect, thank you.
Okay, so, we're gonna be back here. What,
April 15th
April
at
15th.
9:30.
Yes.
April 15th at 9:30? Meanwhile, sir, continuing CATS, cognitive, grief counseling, whatever you're doing over in jail, continue the programming, okay?
Yes,
And
ma'am.
taking your meds, you seem like you're doing better.
I am.
Okay, good. Anything else for the record?
Just that I think I'm gonna be getting a copy of the plea agreement here shortly. I will send him a copy of that by the smart jail mail as well. Thank you, nothing
Okay,
further.
thank you, that's all.
I will
Thank you, Your
send-
Honor.
Thank you.
Send it over so you have it.
4 open files: strangulation, domestic violence, felonious assault, and a defendant who, while facing all of it, kept writing letters. Not letters about grief, not letters asking how his family was holding up, Letters sent through other inmates' accounts, names disguised. With one goal, make the case disappear. That is what the prosecutor told the court. And it landed. The defense had just finished arguing that this man had lost his cousin and his grandmother, that he hadn't been able to communicate with family, that the isolation had affected him deeply. And the prosecutor stood up and said, respectfully, that in none of those letters, not a single one, did he ask about any of that. Every word was about the case, or a plea deal was on the table, offering a 36-month fixed minimum, structured specifically to make him eligible for a rehabilitation boot camp program. Without it, he was looking at anywhere from 62 to 329 months. The judge gave him 1 week to decide. 93 days of contempt were handed down for years of no-contact violations. And then, with conditions attached like a ticking clock, the judge restored limited family contact, with a warning so direct it left no room for misunderstanding. Violate it once, and everything on that table disappears. The defendant said, "You got my word." The judge said, "It better be appropriate." In courtrooms, patterns become records, and records become consequences. This defendant had 4 years of pattern on his record. Whether the next chapter looks different is entirely up to him. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.